Hi, this is Jim Cunningham. We're going to talk about settling a trust after death or dissolving a trust. What are we talking about? Well, lawyers use a term called trust administration, which means absolutely nothing to nobody other than lawyers. What we're going to talk about is settling a trust, dissolving a trust. So in this case, this means somebody's passed away, and we're typically talking about a living trust. So there are a lot of other kinds of trust, irrevocable trust, life insurance trust, QPERTs, all these different type dynasty trusts. What we're really focusing on here is what happens with a living trust when somebody dies. So this is dissolving a revocable trust. This is settling a trust after somebody dies. What, if anything, needs to be done? The first question is, do I need to do anything? Doesn't this happen automatically? Didn't mom or dad do a trust so that we wouldn't have to go through probate? We wouldn't have to do a lot of hard work. Well, yeah, the idea is to avoid probate, but there are other things that need to be done, and we're going to go over that. How badly can this go? We'll talk about that. How do you avoid mistakes? What are some real crucial things that you can do if this is your trust during your lifetime? Like now, right? What can you do to make sure that when you pass away, when your loved ones typically are settling this trust, that it isn't a real disaster? And who's in charge? Who's in charge of all this? Spoiler alert, it's the trustee. We'll talk about what that is. When can people get their inheritance? There is a certain order, and this is very important. We're going to go over 5 steps. These happen concurrently. Some of these happen concurrently. It's not like 1, then 2, then 3, then 4. It's 1 and 2, and then 3 and 4 are happening. But the distribution, you have to be very careful when you distribute that money, because if you're the trustee, once you've distributed, once you've written that check to the beneficiary, there is no legal recourse to get that money back. So it's very important that you want to pay the debts and taxes, and we'll talk about that, what's involved before you actually make a complete distribution. So we're going to go through that. What about taxes? Income taxes, death taxes, estate taxes. We'll talk about that. And do you need a lawyer? Can this be done without a lawyer? Now, I'm a lawyer. I've been doing this a long time. I would say some of these can be done without a lawyer. Some you should check in with a lawyer, and some should be, soup to nuts, cradle to grave. Well, this is a bad example, but beginning to end should be done with a lawyer because there's just too much going on. So, and if you hire a lawyer, what does that look like and how does that work? So I'm a lawyer. I'm a Jim Cunningham. I'm a lawyer. I'm a certified specialist in estate planning, trust, and probate law. I've been an attorney for over 30 years. We have offices throughout the state of California, and I'm a real estate broker, securities and insurance license, as well as a pilot single engine land instrument rated, although I'm not current. And I've been doing this a long time, right? I've seen a lot of mistakes. These are the lawyers in our firm. All of us have experience in trust and estate matters, really focused on the peaceful transfer of wealth from one generation to the next. Very, very important. I am giving you information. Hopefully it will be humorous sometimes, but really this is very important, serious stuff. And don't just listen to this, go out and do a bunch of stuff, because I said, if you hit a roadblock and you really kind of feel like you need legal advice or questioning, maybe I need legal advice, reach out to your lawyer. If you're not represented, feel free to reach out to us and we'll go over how that works. What are the 5 big steps in settling and dissolving, AKA administering, a living trust after the death of the grantor, after the person who creates the trust? There are 5 big steps. So this is where you're going to want to get your pencil and paper out, take some notes. 5 steps. 4 of these kind of happen all at the same time. And that's why I haven't put numbers on them yet. The last one, distribution, is the last thing you want to do. So just very important, if you don't get anything else out of this other than this one nugget, the first thing you do is not distribute assets, okay? You need to do a whole bunch of other stuff before you even get there. So very important to understand, don't just willy-nilly go out and distribute assets. And we'll go through these in depth. Number 1, identify the terms of the trust. Pretty basic. What we're talking about is getting the original trust, including the amendments, identifying the trustee. That may not be as easy as it sounds. We're also going to talk about what the concept of personal representative is, and I'll put that in air quotes, what personal representative is, because that's the term that government uses. And if you see that, you're going to be confused if you don't have knowledge in this area. Trustees have to take control of the trust assets. That means the trustee gets his or her name on those assets. And so that is one method of taking control. You can take physical control of assets, and your name goes on title as well. So this is identifying assets that are in the trust, identifying assets that are not in the trust, but should be in the trust. This gets to trust funding. And again, the big takeaway, if you're thinking about your estate plan, make sure your trust is appropriately funded. Make sure it is properly funded. We have other webinars on this, getting into details on that. And then, so assets that aren't in the trust but should be. And then also, and this may be a little counterintuitive, if you're the trustee, you should also identify assets that are not part of the trust that pass to others by beneficiary designation. We'll talk about, it's going to be like IRAs, annuities, 401ks. The reason for that is the government on the federal estate tax system, they tax those assets that pass by beneficiary designation. So if a beneficiary, an inheritor, gets a $5 million IRA, the personal representative of the estate, and we'll talk about that, is required potentially to add that to a federal estate tax return. So even though that person, that trustee or executor does not have control of that asset, that is an asset that is reportable. Winding up the affairs of the decedent, we're going to talk about following all the rules. There are notices that have to be given to various governmental organizations, okay? And also beneficiaries, trustees, people named in the trust, people not named in the trust. We'll talk about that. Pay debts, expenses, and taxes. And finally, the distribution. So if you're a beneficiary watching this, you go, wow, I just want my money. But we'll talk about what that looks like. So first, what is a living trust? Very briefly, and if you already know what a living trust is, go ahead and fast forward this video if you're watching this on YouTube. What is a living trust? It is a bucket with it, figuratively speaking, it's a bucket with a handle. You put your assets in that bucket. Stocks, bonds, mutual funds, real estate, shares of your LLC, shares of your S Corp. Your trust has to have certain provisions if you have S Corp shares in there. Don't forget that. The trustee holds on to the handle. So if this is my living trust, I'm putting my house, stocks, bonds, mutual funds, my IRAs, 401ks stay out, life insurance stays out, annuities stay out. I'm holding onto that handle. When I stop being trustee, so if I stroke out or I die, that bucket passes to the person who's identified in the documents as the successor trustee. That person then becomes trustee, drops the successor term and is just the trustee. So if you hear people talk about successor trustee, it's not really the current acting trustee. So if you've been named as successor trustee and now you're trustee, you would just call yourself trustee. The benefits are privacy. This is a huge benefit. Living trusts are private. The terms of the trust are not public. The terms of a will are public. You go through probate, it's public. Avoidance of probate court, and in many instances, minimization of taxes. Other benefits can include protection from future ex-sons-in-law, future ex-daughters-in-law, predators, and divorce. Living trusts are significantly better than a will. Why do people do a living trust? It's estate planning, tax planning, asset protection for the inheritance they're leaving people. And living trust in California at the core of many plans. So really, this is peace of mind, right? People do a living trust instead of a will to give peace of mind. What is a successor trustee? Again, it's the person named in the trustee to manage, dissolve, and settle the trust, right? It's this person who's not the person who created the trust. It's a human being with a heartbeat who carries out the terms of the trust. Now, if you name, for example, Premier Trust as your successor trustee, there will be a trust officer who is the human with the heartbeat that will be signing on behalf of the entity, which is Premier Trust, and they're based in Nevada. We use them quite a bit. But you're going to have a human with a heartbeat. This is something where a human has to sign documents. So someone who's alive. So if you're dead, you can't be a trustee. You have to follow the terms of the trust as written. So this is very important. Trustees must follow, they can't deviate from the terms of the trust, have to follow the terms of the trust as written. They're to marshal and manage the trust assets, follow the rules. This is not only the statute, the California Probate Code in California, it's case law, so this would be federal and state case law, as well as doctrine. Doctrine is something that is not necessarily a law or a particular case, but it's an idea that the courts follow and enforce, and communication with beneficiaries. So we'll get in the weeds on this, we'll hit our 5 steps in just a minute. Very important to understand the difference between ownership and control and rights and duties. Trusts involve 3 parties. Whenever you have a trust, you're always going to have 3 parties. You're going to have a trustor, which is the person who sets up the trust. There's a lot of different terms on that, and we'll cover that in another slide. The trustee, this is the person who's in charge of the trust, right? This person who's driving the bus. The trustor creates the bus, trustee's driving the bus, and the beneficiary, they own the bus, right? They're kind of the passengers on the bus. The beneficiaries, when you have a trust, you have to have all 3. If you're missing one, you don't have a trust, right? The trustee controls the assets. The trustee has what we call legal ownership. That means that the trustee's name is on the deed to real property. The trustee can sell the property, can transfer the property, can manage the property, collect the rents, make distributions, pay the taxes, whatever that involves. The trustee is the person doing that, not the beneficiary, okay? The beneficiary holds what we call beneficial ownership, also called equitable ownership. And this is really the true, I would say the true owner of the property. So the trustee controls it, but really the owner of that property is the beneficiary, the person who's entitled to the goods, hence the term bene from Latin, meaning good. The beneficiary lives in the property, not the trustee, right? So if the trust owns the property, the trustee's on title. That does not mean the trustee can live in the property. That means that the beneficiary lives in the property. And if the trustee rents the property out, the trustee doesn't take those rents. That's not the trustee's money. The beneficiary is entitled to the rents, not the trustee. The trustee owes duties to the beneficiary, but has no rights, I suppose, other than compensation if it's written in there. The beneficiary has a bundle of rights, right, but no duties. And the headline on this is beneficiaries can be complete jerks. They can be the big babies. The trustees have to be the adult in the room, and they have to do the right thing. They have 100% personal liability, and we'll talk about that in a little bit. So let's get to it. 5 steps in dissolving a living trust after the death of the grantor. What are they? Step number 1, identify the terms of the living trust. Now, you may say, Jim, that's pretty easy. Isn't it just straightforward? Isn't it written down? Well, yes, not necessarily easy. Living trusts, unlike an irrevocable trust. Living trusts are amendable and revocable, but the problem here is amendable during the lifetime of the grantor, the person who creates the trust, that sets up the trust. A person can create a declaration of trust or a trust agreement. So you might see this term if you have a trust that you're looking at, and you go, gee, what's the difference between declaration of trust and trust agreement? You might not even have known to ask that question. A declaration of trust is typically when the grantor creates the trust and the grantor serves as trustee. So the grantor sets up the trust and the grantor is serving as trustee in the beginning. Many times that's called a declaration of trust. If you create a trust and somebody else is serving as trustee, a trust is fundamentally a contract. That is not necessarily a declaration of trust. That is going to be a trust agreement because the settlor, the trustor of the trust creates a trust. Someone else who's the trustee is the trustee of that particular trust. We don't see that too much in living trust, but just know that there's a difference. So an example here between a trust that's amended versus restated, and it's very important to understand the difference between an amendment and a restatement. Able creates a living trust in 2010, amends a trust in 2014, 2018, 2022, and 24. So Abel's trust is a document with 4 separate amendments. Now, this can be very cumbersome to administer. It's like a book that changes, page 12 and then 15 and 18, and it's kind of hard to follow all this. So we'll talk about a certificate of trust in a couple of slides, but this is where an abstract of trust might be helpful. So if your lawyer is saying, hey, we're going to do an abstract of trust, or if a banker says, gee, we really need an abstract of trust, what this is this is a trust with the 4 amendments, and the lawyer typically rewrites a new document, and it is called an abstract of trust that correctly recites the important terms of the trust. So if you have a trust, then you have beneficiaries, and you change different beneficiaries through 4 iterations document to make things clear. Otherwise, this is very hard to administer. So I guess a takeaway from this is if you have a living trust and you've amended it 4 times, you really should think about doing a restatement. Well, what's a restatement? Well, in the Baker example, Baker created a living trust in 2010, amended it in 2014, 18, but in 22, but in 2024, which would have been the 4th amendment, that is what we call a restatement. So that 2024 document completely effectively obliterates all prior amendments. The only thing under California law we're looking at is that 2024 restatement. I would say if you have a trust and you amend it once, probably okay. If you start amending it 2, 3, 4 times, you might want to look at doing a restatement. And talk to your lawyer about that. And that's something, if you're a client of ours, we would talk to you about. But this is not make work for the lawyer. This is actually making it easier on your trustee, because you don't want to have to do that extra step of an abstract, because that abstract of trust may cost more than doing a restatement, by the way. So it might take a lot of effort on the part of the lawyer. So that is step number 1. Step number 2 is identify the key players in the trust administration process. So when we're talking about settling a trust or dissolving a trust, who are the key players? Who is the trustee, right? How do you prove that you're a trustee? Well, you got to walk around with a copy of the trust, and then there's something called a certificate of trust or a certification of trust. And this is certificate of trust says under California law, this is the trustee, this is typically the trustee's address, this is the taxpayer identification number of the trust. We'll get to that. You don't use the grantor's social security number once they've died, but this is a document that typically a lawyer will create that the trustee can take around. So instead of producing a copy of the trust and a bunch of other documents, you're simply producing the certificate of trust. Now, under California law, institutions are required to honor that. They don't always honor it. Sometimes they'll want more documentation. If you're selling a piece of property, the title company may ask for a copy of the trust. And if you say, well, gee, I watched Jim's video and you only need the certificate of trust, they may not issue a policy of title insurance, and you may have to find another title insurance company. So just understand that sometimes people are going to need to see the whole trust. Sometimes they're going to need to see the certificate of trust, which is like a 2-page form that's notarized. Who is a personal representative? Personal representative is a very broad term that encompasses executor, administrator, administrator with will and X, special administrator. Those are the 4 types of executors in a probate. It also potentially covers trustees. So within the context of reporting to county and state agencies, the term personal representative, you can be the trustee and be reporting that, but this is a very broad term. This is the person who is acting on behalf of the decedent or the decedent's estate. Decedent is a term that means dead person. It's just a nice way of saying it. So who are the beneficiaries? This may sound, you go, Jim, well, that's just a dumb question. Of course, just look at the trust and it'll say who the beneficiaries are. Well, not so fast. Charlie names Delta as successor trustee, but Delta's deceased when Charlie dies. Who's the trustee? Well, I can tell you it's not going to be Delta because she's dead. Trustees have to be a human being with a heartbeat. So someone else is going to be the trustee. So you have to look at the trust document. If Echo is potentially the successor trustee after Delta, then Echo may need Delta's death certificate to prove that Delta is no longer able to serve as trustee. But what if you don't have access to Delta's death certificate? You can see where if Charlie knows that Delta's passed away, he should probably update his estate plan because it's just going to make it easier on the person in line after Delta, in this case Echo, to serve as successor trustee of Charlie's estate. And another example is Charlie's Living Trust directs Charlie's estate to be distributed to Delta, who's dead. So now we're not talking trustee. We're saying, hey, Charlie's leaving everything to Delta. Who are the beneficiaries? Well, if you're dead, you've got several options. One, it could go to Delta's estate. It might go to Delta's issue, which are Delta's descendants if Delta is a child of Charlie. But if Delta is not a child of Charlie, this is called the anti-lapse statute, you may have a different outcome. We look at the trust. The trust should say, I'm Charlie, I leave everything to Delta. If Delta does not survive me, then it goes to whatever. But we need to figure that out. So India's Living Trust directs the trustee to distribute the assets to India's then living issue. What on earth is a then living issue? This is not then living issues, right? This is not India's personal issues. Then living issue are India's lineal descendants as defined under the California Probate Code, which I can tell you is not necessarily biologically related to India. It could be a child that India held out as her own child. Maybe a child that India was taking care of, but never adopted. Very broad. California has a very broad definition of parent to child, but issue means parent to child relationship at each generation. So that's going to require some lawyer work. I would not want to do this if you're a lay person to try and figure this out. And again, you don't know what you don't know, right? Step 2, identifying the key players. I'm putting this slide up here because I'm using the term grantor. Other trustees, other attorneys use settlor, trustor. We use a lot of these. I would say we're using 4 or 5 of these, depending on the sort of nuanced case. But a grantor is the big, typically that's the one you're going to see in most estate plans in the United States. Settlor you're going to see in the UK and other English-speaking countries. So sometimes we use settlor in the United States for different contexts. Trustor, it's often used in the US interchangeable with grantor. Then you have donor, creator, founder, principal, trust creator, establisher, or maker, or trust maker. Again, these are all terms that have different nuances, and I've got descriptions. Principal is one, by the way, interesting. Principal is used very commonly on powers of attorney, like a durable power of attorney for property, durable power of attorney for healthcare. You talk about principal and agent, or in a trust, you would talk about grantor and trustee. So, identifying the beneficiary. How to identify the beneficiary? You can be named. In this case, a person's name, Sierra, is a beneficiary of the trust. You can be described as issue or descendants. So Romeo's issue, so that the trust property is to be left to Romeo's issue. What does that mean? Is it the same as descendants? Not necessarily. So we need a lawyer involved. So I would say, we're going to talk about this in the second half of the video. When do you need to hire a lawyer? Well, when these issues come up, and this may be a single meeting with a lawyer to figure this out. And that's something that we do offer in our firm. So if you say, gee, I'm halfway through this and I just need some legal questions asked, go ahead and reach out to us and we're going to walk you through how that works. You can have a combination of both. So if Sarah's predeceased, what does Sarah's issue mean? What if Sarah survives Romeo but fails to survive the complete distribution of the trust? Very interesting. If Sarah survives Romeo, so Romeo's trust leaves everything to Sarah, but Sarah dies before she gets her inheritance. Who gets Sarah's inheritance, right? We would have to look at the trust. Inventory of trust assets. Do you need probate? This is identifying the trust assets. Super, super important. Assets should be in the name of the trust. Now, typically they're not. We see this, that assets are in the quote, the name of the trust. Typically, they're going to be in the name of the trustee of a particular trust. So when that trustee dies, you're going to have to swap names out. And then again, that's part of dissolving or settling a trust, part of this trust administration. So an example would be Abel, trustee of the Abel Trust dated January 30th, 2010, and any amendments there too, is a typical way you would, certainly on a deed, you would describe the ownership of the property. Now, you wouldn't just say the Abel Trust dated January 30th, 2010. When Abel dies, and we're going to go through this, what you need to do to remove Abel's name. So you need to identify the assets that should be in the trust but aren't. This is the importance of funding your trust. So if this is your trust and you're alive, please make sure your trust is properly funded. This is a nightmare for your beneficiaries. It's a nightmare if you become incapacitated and people have to figure out what should be in the trust, what shouldn't. It gets very complex very fast. Assets not in the name of your trust are subject to probate. So if that asset is in Abel's name, let's say Abel never signed the deed before a notary public and never recorded the document with the county recorder's office, which is, you don't record them with the state, you record them with the county, is likely going to probate court, right? Because Abel didn't get that property into the trust. So it's very, not a lot of work for Abel to sign a deed. So if you've done your estate plan or you're looking at doing an estate plan, or maybe you're worried about somebody that you might serve as trustee, please make sure the real property that it should be in the trust is in the trust. A lot of times people refinance a property and pull it out and it never gets back into the estate. So whether you go through a full-blown probate, this sort of 2-year process, or a single hearing, really depends on the facts and circumstances. And that's something where you would want the involvement of an attorney, someone who could represent you in court on that. That's really something you don't want to do on your own. Step 3 is also what other assets should be owned by the living trust? Well, bank accounts, investment accounts, stocks, bonds, mutual funds, real estate, membership interest in an LLC, which is kind of like the shares in an LLC, partnership interest, S-corp stock, but you should have certain provisions in your living trust so that you don't cause the S-corp to become a C-corp, which could be problematic, and then personal property. Automobiles typically are not trust owned in California, so it's a more modern approach. We leave those out. Those pass by affidavit 40 days after the death of a decedent. So like Noah was in the ark for 40 days. At 40 days after somebody passes away, you can transfer those by affidavit. Yes, I am taking a breath. Identify assets should not be in the trust. IRAs, 401ks, tax sheltered annuities, thrift savings plan, those pass by beneficiary designation. Those are typically qualified accounts. We include Roth in those. Those don't go through your trust. Those typically pass by beneficiary designation. By the way, even if you designate the beneficiary of your trust, which I'm not in many respects not a fan of, we use a separate trust for that, the IRA Legacy Trust. And we cover that in our book, Savvy Estate Planning, why you might want to use a separate trust for your IRAs. When those flow through, if they do land in the trust, it's because somebody has named the trust as death beneficiary. So when I die, those assets go to the trust. Those are not in the trust while a person's living. Annuities, life insurance typically stay in an individual's name. And again, although these assets pass outside of the trust, they still count when it comes to death taxes. So currently for 2025, the limit is about 14 million, but then you have state and other inheritance taxes. And so you may have this weird situation where somebody may inherit something and then there's a tax due, but then how do you get, if someone inherits a $5 million IRA, how are you going to get the tax back? Well, it's a problem, right? You're going to need the involvement of a lawyer. So inventorying the trust assets, taxpayer identification number. A lot of these are happening concurrently. They're not necessarily consecutively. Applying for a taxpayer identification number from the IRS using form SS4. The trust becomes irrevocable when a person passes away. irrevocable trusts become irrevocable when the person passes away. You cannot use the grantor's social security number. I guess the one exception would be a joint trust. And again, we're using the context of a single person's trust. But if you're married and you have a joint trust, it is possible that the surviving spouse, that trust does stay revocable and amendable. So you could continue to use a living grantor's social security number, but certainly when, in the context here, we're talking about all grantors are dead. So you can get that as an individual. Your CPA or your lawyer can get it, but please do your advisors a big favor. Again, second nugget, only get one, don't get two. It is a nightmare if you get two for us, the lawyer. It's really hard to pull the cream out of the coffee, so to speak, when you get that second taxpayer identification number. And as you might know, dealing with the IRS is a bit like talking to a brick wall. And if you work for the IRS, I'm not blaming you. It's the structure. Okay. It's not the people working at the IRS. It's the structure. So this can really actually be kind of expensive to resolve this two taxpayer identification number issue. So please, all these people need to talk. You, your CPA, your lawyer need to talk. Inventorying the estate death certificates. How many should you get? I'm just going to throw out a number 10. Somebody dies, get 10 death certificates. You can get those from the funeral home. It's easier. You can get them from the State Department of Vital Statistics. You might get them from a county, depending on what state the person dies in. It's really state specific, maybe locality specific. But 10 is kind of a good rule of thumb, and keep those because you might need those in the future. You might need those well into the future. Additional death, and I would say get one additional death certificate for each parcel of real property. So if Abel dies owning 5 condos, Baker, Abel's trustee, would get 15 death certificates. So 10 plus 5, write one for each parcel of real property, because many times that death certificate is recorded at the county recorder's office, and sometimes you have to record 2. So I would say it's something, spend the money on it. It's going to be a couple $100 to get that many death certificates, but it saves you hassle down the road. What about appraisal? Very important. We talk about this in other webinars. Assets that are in a living trust typically get an adjusted cost basis. What is that? All right. If India paid $100,000 for a house, and when India dies, that home is worth $1 million. And Juliet inherits India's home. Juliet can sell that home for $1 million right after India passes away and not pay any capital gains tax. It's going to save over $300,000 in California. This is a big, big deal. Okay. How do you know it's worth $1 million? Well, I suppose if India turns around and sells it, you're going to know because you have a sales price. But what if India holds on to it and she sells it 10 years later? You are going to want to get an appraisal. You're going to want to get property appraised. Cash, you don't need an appraisal. Cash is cash, right? It is what it is. Stocks, there's a mechanism to appraise those. It is not the closing value. It's the mean between the high and the low, and there's software that does that. Real estate, you're going to go through a certified real estate appraiser. Now, can you get a broker's, opinion of value? Yeah, I would rather have an appraisal. If you're talking about a $900,000 capital gain, I don't want that questioned. And it's not going to be questioned if an appraiser appraises the property and you've got that thing. And let's say India waits 10 years or Juliet waits 10 years to sell the property. If I'm Juliet, I'm going to want that appraisal that has it at $1 million. The other thing that's important is you want to have that even property you hold, like rental property, you have a new basis and you start redepreciating that property. So this can really save you a lot on income tax. So I would say if you have rental property, if you have real property that you're not going to immediately sell, you really do want to get that inventory value because you're going to need that in the future. And again, this applies to investment accounts, stocks, bonds, mutual funds, real estate, partnership interests, and personal property. So those all should get an appraisal. Next is completing tasks to wind up the decedent's affairs. Notice, as a trustee under California law, you are required to provide written notice to the trust beneficiaries under California Probate Code section 16061.7, 16061.7, and the legal heirs within 60 days of the grantor's death. Now, here's the issue. You have to, best practice, every single person who's been notified in a trust, plus all amendments, even if they're in, now they're out. All those people have to get notified. Now, if it's a restatement, as we read the law, you only notify the people in the restatement plus any amendment to the restatement. You're not going back on prior documents, right? That's if there's a restatement. But here's the important part. Not only do you have to notify all the people named in the document, you also have to notify all the people who would inherit in the absence of that document. Now, some trusts don't name the quote intestate heirs, the people who would inherit in the absence of a trust, because it's not required in a trust. But if it's a revocable trust, that is on the trustee to figure that out. So the trustees can have some homework. Now, a lot of times the trustee is a child. Hopefully you're going to know your parents' children, right? But if you're a trustee for a friend, you don't know, right? So again, I would say pause. You're notifying not everyone, not just the people listed in the trust, but also the people who would inherit in the absence of a trust. Those are what we call the intestate heirs. This is served by mail. Electronic service is not valid unless you get consent to electronic service, which it's easier just to mail it. You should keep a proof of service. So a proof of service it's in the judicial council forms, the California court form documents. Basically, this proof of service says, I have sent these documents, and could be admissible as evidence to prove that these were in fact sent. So it's good to keep that proof of service. It's optional whether to include a copy of the trust or not. Many times we include a copy of the trust. Sometimes we don't. But the person has 120 days from the date that they received the notice. If you send the notice and a copy of the trust, they have 120 days to challenge. So if they file something 121 days, doesn't count. If you send the notice but don't send the trust, and on the 119th day, they say, oh, I want a copy of the trust, they have 60 more days to challenge the trust. So that's where the advice of a lawyer is helpful, is to determine, should we be sending the trust or not? One downside of sending the trust is a copy of the trust is out in the ether. It's just out there. So again, I think this is case by case, and it's something you should consult a lawyer on. Typically served by U.S. mail to the last known address of each person who is named in the trust. And this is like successor trustees. This is, if you leave someone $10 or your church $1,000, all these people are getting notice. The notification must contain the identity of the settlor, so the person who died. Again, the code uses the term settlor. We may use the term grantor. That's why I had that slide up there. It's basically the same thing. The date of execution of the trust and any amendments, the name, address, and telephone number of the trustee. And if you're the trustee and you say, I really don't want that wackadoodle person knowing my name, address, and telephone number, you're going to have a problem, because this information has to be provided. So this does come up. Where you might be the trustee, you might have a restraining order against the person. And so you might think twice about serving as trustee because this information has to be provided. So, these are real world cases that we've had to deal with in the past. You notice the recipient you notice the recipient that they're entitled to receive a copy of the trust if you're not including a copy of the trust. And there is a warning in not less than 10-point boldface type. So if it's 9-point, it's not valid. If it's not boldface, it's not valid. I don't know why the legislature is specifying the type font. Who knows this stuff, right? Quote, you may not bring an action to contest this trust more than 120 days from the date of this notice. Or if you've not been served a copy of the trust, you've got an extra 60 days. So that has to be contained in there. And then real estate. So very important, real estate gets its own separate treatment. An affidavit is typically filed in the county where the real property is located, not the county of death, but where the real property is located, indicating that the erstwhile trustee, so I'm assuming that the grantor was trustee, so it's trustee's dead, so they're not trustee anymore, hence the term erstwhile. And if you don't know that term, it's kind of a good term to know, is no longer the trustee. This is filed by the successor trustee. Again, I mentioned the successor trustee drops the moniker successor and just becomes the trustee. So this is filed by the person who's identified as successor trustee or somehow appointed trustee, but they just use the term trustee. They're not using successor trustee. And this typically requires a death certificate, which redacts the social security number. But here's a question. This affidavit is filed and the grantor's death certificate is attached, and that's a public document. So do you want your death certificate to be a public document recorded? I'm not sure I would want my death certificate to be recorded. It might make sense not to be the trustee when you die. So how do we do this? Well, if you're a grantor and you're ending you're close to the end of your life, you may want to resign as trustee and have your successor trustee start serving, and then you don't have to record that death certificate. So death is a change in ownership. This is very, very important. Property is reassessed at its fair market value at the change in ownership. Person dies January 30th, 2025. That is the change in ownership. January 30th is a change in ownership. even though nobody knows it's a change in ownership. The assessor is going to say, aha, when the grantor died, that is a change in ownership. Property's reassessed. You're going to lose your Prop 13. Property's taxed at a minimum of 1% of its fair market value. There are some other add-ons on there. There are potentially parcel taxes, other ad valorem taxes or taxes that are based on the value, on this assessed value of the property that maybe have been passed by local initiative. And those can be increased a maximum of 2% a year thereafter. These, we're talking about the ad valorem taxes. And so that goes to the county. The notice of change in ownership, death of real property owner, goes to the county. It is filed by the personal representative. Sometimes it's the trustee, sometimes it's the executor. They file a separate statement with each county for each parcel. So person dies a resident of LA County, owns a property in San Francisco County. You're not filing that affidavit in LA County. You're filing it where the property is located. If they have 10 properties, you're filing 10 change in ownership, death of real property owner, separate documents. If you own 100 parcels of property, you're filing 100. If you own 500 parcels of property, you're filing 500. So it's interesting because this is one reason why people who hold multiple parcels do LLCs, because it significantly reduces the workload when somebody passes away. So speaking of LLCs, if property is in an LLC, that means that the trustee is not on title. It means that the LLC is on title. So if you own Greenacre LLC is the owner of the property. What do you do? Is there a change in ownership? If I own all the shares of Greenacre and I die, it depends. We cover this in other webinars. But if there is a change in ownership, and you really need a lawyer on this, if there's a change in ownership, a statement of change in control and ownership, BOE 100, is filed with the State Board of Equalization in Sacramento. It is not filed at your local county recorder. So this must be completed and filed with the Board of Equalization within 90 days of the change in control or change in ownership. We cover this in other webinars. If you have real property in an LLC and you're administering a trust, I don't think you need a lawyer, and we'll talk about how to hire a lawyer on this. But it's very important to understand these, by the way, the penalties are pretty severe. And if you don't do anything and 20 years go by, you're going to be liable for 20 years of penalties. Not the same case if it's an individual, unless it's intentional. So unlike probate, there's no requirement to notify creditors for California trusts. Other states do require notification to creditors or notification of creditors. Michigan is one of them. California doesn't yet require it. Might they in the future? I don't know. Pay any outstanding debts, bills, or taxes owed by the grantor or the trust, and keep good, detailed records of all expenses paid from the trust. More on that in a little bit. So the expenses, you want to keep detailed expenses. Some expenses are allocated to a specific beneficiary, others are not. A pecuniary gift, a money gift, has to be paid within a year. I give, my brother $100,000. If that gift is not paid within a year, then that gift gets interest, okay? Who pays that interest? Probably the trustee, if the trustee's been sitting on their hands. So pecuniary gifts typically don't accrue interest unless it's been more than a year. Pecuniary means money. Specific gifts are chargeable with expenses associated with such gifts. What do I mean by that? Abel leaves Red Acre to Charlie. The expenses of Red Acre are chargeable against the income from Red Acre, right? Or potentially principal of Red Acre, and not to the trust overall. So if property taxes are paid, those property taxes go up. The trust itself isn't paying those, but that comes out of the pot of money separate that's carved out because Charlie got Red Acre. And just something to know. And again, this goes into tracking expenses. Again, if you have a specific gift of real property and it's a rental property, that's probably where you want the involvement of a lawyer. You file the grantor's final personal income tax return, which is the 1040 for the year of death, a 1041 if the income's beyond $600 in a given year. You're not going to pay taxes at the higher rate if that income is distributed to beneficiaries, but you still have to file the return. And determine whether a federal estate tax return is required to be filed or should be filed. Again, we cover that in other webinars. And determining whether any state or local filings are required. So state inheritance tax, state death tax, those sort of returns. Records, document all actions taken as trustee, including distributions and payments. You got to keep records. Do not withdraw cash from an ATM. That's literally the worst thing you can do. If a judge sees that, they're just going to think you're a crook. Provide beneficiaries with a final accounting of trust activities. Final accounting is a lot like a bank statement. This is what we started with. This is all the money that came in. This is all the money that went out. This is what's left over. Here are your checks. That's an accounting. You got to have good records to create that accounting, and then you close out the trust once all the distributions and obligations are complete. Distribution of assets to beneficiaries. Follow the trust instructions for outright distribution of assets. If the trust says thou shalt distribute to Johnny, and Johnny is a complete dirtbag and is going to blow the money, you got to distribute the money to Johnny. Like, there's no way around that, right? It's just, unless the trust provides another mechanism for that. So again, mindfulness about estate planning. If you don't really care if Johnny blows his inheritance, most of our clients care. So they're going to say, I want to put some guardrails up. So that's where you're going to need a lawyer's help. You transfer real estate by preparing and recording deeds and file a preliminary change in ownership report. That is when you distribute the assets. So the trust is settled. We're going to distribute Red Acre to Charlie. You do a deed that distributes Red Acre to Charlie. Provide the necessary documentation to institutions for transferring accounts. They're going to ask for certain paperwork. You're going to need to provide that. If the trust requires trust property to be retained in trust, for example, if disabled or a minor beneficiary, you really should seek legal advice on that. There's a lot of ways you can step in it. And I would, you don't necessarily have to have an ongoing relationship with the lawyer, but reaching out to a savvy lawyer who knows what they're doing really can help. It is a legitimate, expensive trust administration. Hiring an attorney and typically attorneys are doing this on an hourly basis. They're very expensive. Trust administration attorneys charge a lot more than a normal attorney because they know what they're doing. And they're going to give you good advice, and they're going to probably take 1/10 the time that somebody who doesn't know what they're doing to get you to the same spot. Should you have a savvy lawyer help you with dissolving and settling a living trust? This is a great question. Do you need to do anything? Number one. Secondly, do you need help doing this? Right? Should you have a lawyer? Without a professional's help, now whether this is a lawyer or a CPA, sometimes financial advisors will try and help. I think a lot of times it's hard to understand what's the purview of lawyers, what's the purview of CPAs, financial advisors, real estate agents, other people. So that's not exactly a clear line. But I would say, broadly speaking, with professional help, that typically includes the lawyer. You don't want to improperly account for assets, right? Or fail to account for assets. Getting the date of death values wrong. That, sometimes it's complex. And don't create a tax disaster, especially with retirement accounts. Sometimes a financial advisor will immediately roll over an IRA if a spouse has died. Well, that may mean that spouse pays a 10% penalty if they want to take, if they're not 59 and a half yet. So you may want to look at something else. Certainly with annuities, there are different settlement options if you're married on annuities. So these are things that a lot of just general practitioner lawyers don't know, but the savvy estate planning lawyers are going to know a lot better. Filing an incorrect deed or not at all, yeah, getting it wrong, that's a tough. Not only are you going to spare yourself enormous hassles as a trustee, but potentially you have 100% liability as trustee, even for stuff that you don't know. That is stuff that you should know, but don't, right? You should have gotten the legal advice. Yeah, you're still held accountable for that. So how can a trust administration lawyers help? Lawyers have the experience and the background to follow the law, case law, doctrine, and statutes, and the ability to help protect the trustee from personal liability. So one example is an investment policy statement. If you have a bundle, depending on how your trust is written, if you hold a bunch of stocks, some go up, some go down, the trustee can be held personally liable for the stocks that go down, and you don't get credit for the stocks that go up. So if you have a particularly contentious beneficiary, you may want to consider having an investment policy statement. What an investment policy statement says is, I'm the trustee, I've thought about it, and it is in the best interest of the trust to have these assets as they are. Some will go up, some will go down, and that absolves the trustee from liability. So very important to pay attention to that. So how can a lawyer help determine if an estate needs to go to probate or not? So this is the situation where you've hit a roadblock, and it's an institution. Maybe it's a title company. Somebody has said, you need a court order. You need to go to probate. Very common. So sometimes probate is necessary, even if you have a living trust. If you don't have a fully funded living trust, by the way, if there's only a will, you're going to probate. If there's no will, you're going to probate. So a will doesn't keep you out of probate. If you do not have a fully funded living trust, you're going to be looking at probate. When the assets in the name of a deceased person are greater than $184,500, for 2024, then it looks like you're going to probate. So if you have a bank account that's 200,000, you're going to probate. If you have a bank account that's 100,000, there's a different mechanism for collecting that. And you can work with an attorney on that. You can work with someone at our firm on that. So probate many times is the only way to dispose of or otherwise transfer the decedent's property to the people entitled to it. So an example is if the kids want to sell mom's house and mom's name is on the deed, mom's not there to sign it because she's dead, right? You're going to have to go another path. That is the path of probate. Now, there's a full-blown probate that takes a couple of years. There are some other types of proceedings that take a lot less time. So we're looking at probate, we're looking at trust administration, we're looking at trust termination and dissolving the trust. So what is the number one reason why trustees should get a lawyer? By the way, the trustee is the client of the lawyer, and so the attorneys owe a duty to the trustee and the duties owe a duty to the trust itself. Trustees have 100% personal liability for everything that goes wrong. You know, it's like John F. Kennedy said, failure has 1,000 fathers and failure is a bastard, success has 1,000 fathers. And if something goes wrong, everyone's going to turn and is going to blame the trustee. So, how do you know what to do? How do you avoid this liability? Okay. Well, following the terms of the trust. And sometimes the terms of the trust, as trustee, you look at these and you say, you know what? These totally don't make sense. This is absolutely not what this person wanted. You know, Johnny's going to blow the money. They would be rolling in their grave. And sometimes there's nothing you can do about it as trustee. Okay. Sometimes there is, but many times there isn't. And so if you try and do something that you can't do, if you try and contravene the terms of the trust, you're going to get in trouble. And understand different rules apply to incapacity versus death. We've been talking about death, but if somebody is incapacitated and some assets are in their name individually and in maybe an account jointly held with somebody else, and then maybe a transfer on death account and a payable on death account and the living trust, there is in fact an order of liquidation on those accounts, and it is not even. So some come out first, and then when that's drained, then you go to the next account. And if you get that order of liquidation wrong, you're held personally liable. Rules are arcane, cryptic, and sometimes counterintuitive. These are written by legal professionals, and they're written in literally a different language. So I would say seek out competent, savvy legal advice, definitely not a do-it-yourself project. The lawyer's office. So what is the role of a lawyer in a lawyer's office? They can help gather appropriate documents and assets. So this is part of, you have to find the important documents. And I will tell you, we've had in California, we've had a series of natural disasters. Most recently, the Eaton and Palisades fires. And if you've been affected by those, I know from personal experience what it's like to go through that. And my heart goes out to you. And many of our clients were affected. And growing up in California, everyone is affected to one degree or another. But it is important, if your documents are destroyed, that's a major problem. If you can't find the original of your trust, that very well may be a problem. So in our firm, if people have their documents destroyed, and this, again, one reason you want to hire a law firm to do your estate plan, we generate essentially a certified copy of those at no charge for our clients. So if you're a client of Cunningham Legal and you've lost your documents due to fire, we're going to go ahead and create essentially an authenticated copy for you so that you have your estate plan. So we're looking at the estate plan, we're looking at the trust, we're looking at the will, the lawyer's looking at the assets, funeral instructions, deeds, death certificates. We're helping the clients get all these important documents together. You gotta find all the assets. So you can't do a halfway job on this, okay? Person dies, you got to find out what are all the parcels of real property that this person owns. Now, for many people, this isn't an issue, but for some people it is. Retirement accounts. This can be surprisingly difficult because if you're not named as the beneficiary on those retirement accounts, that institution may stiff arm you. They may say, we're not going to give you the information. So how do you get that information? It's a tough one. Bank accounts, health savings accounts, cash, personal property, safe deposits, stocks, bonds, life insurance, annuities, timeshares, crypto. It's a big one. That can be, that's a whole separate topic, crypto. Non-US assets is another one. Many of our clients have assets that are, maybe from a condo in Cabo to maybe some family property in another country, vehicles, collectibles, a lot of other assets. Typically it's the trustee who's inventorying all of this. It's the trustee who's creating a master inventory of all assets. And then there's a sub account of trust assets, but many times the trustee is the one filing the last income tax return, filing the estate tax return, and they very well may need access and information on all of these assets. So how do you contact a trust administration lawyer? What do you do? Well, we offer a 15-minute call with a client specialist. Now, this is not a lawyer, to help you determine if it's time for trust administration or probate. Is it time to talk to a lawyer about this? We offer a paid 1-hour consult. So if you're in the middle of doing this yourself, maybe you're starting, you're overwhelmed, you watch this video, you're like, oh my gosh, I can't do this alone. I'm just nervous. We have skilled lawyers and skilled paralegals and staff people to help you. So we are here to help you. And but that's a paid engagement. So the whole era of free consults are over. Even if you're an existing client of ours, we do have a reduced fee to sort of because you're a returning client. But there is a free 15-minute call with one of our client specialists, and she can go over that with you. What does a trust administration lawyer do? Interesting. We help determine the accurate value of the estate, and we work with qualified appraisers. And here's an example where this is not as simple as it looks. What if you own a 1/3 interest in a piece of property? That is not worth 1/3 of the property. It's worth probably a little bit less, right? Because you only own, who's going to buy a third, right? So that is helping you get through the accurate value of the estate. We work with qualified appraisers. We help inventory the assets, including things that are not in the trust, which I mentioned. We review financial statements, and we consult with professionals. We have a wide bench or deep bench of professionals that we work with. These would be certified financial planners, certified public accountants, real estate appraisers, art appraisers, jewelry mediators. If you get, if disputes with beneficiaries, real estate professionals, and many, many more. So we have those at the ready. You're not going to have to go out and reinvent that if that's something you need. Resolve any outstanding debts and expenses. So identifying the debts, and this is something if you had a parent die and you're the trustee of the trust, once you give the credit card company your phone number, what do you think they're going to do? They're going to call you and call you and call you and call you, and they're going to try and collect that debt. So, sometimes we help with insolvent estates. This is where somebody has more debts than assets, and you really need a lawyer on that. And I think the best thing to do is have your lawyer reach out to the creditor. So if that creditor, is sending you nasty grams, don't reach out, have the lawyer reach out, and it gives you a buffer so that they're not hounding you at all hours of the night. Notification creditors. In many jurisdictions, the law requires known and potential creditors be notified of the decedent's death. Not in California, but in others, that's the case. But again, you want to probably pay those creditors, right? Or not. Again, it depends. Is it a valid creditor's claim? And what if the creditor's claims or the debts exceed the assets? So that would be a special situation. Validation of claims to make sure that they're legitimate claims, and then payment. So sequencing and timing of payment. Which bucket of assets are you paying those from? Which have tax consequences, which don't have tax consequences. Very important decision making. Use of exemptions and credits. So there is some post-mortem tax planning that can happen. Typically, a spouse, if they inherit from another spouse, they're covered by the unlimited marital deduction, unless you're a non-citizen spouse inheriting. There's something very important called a portability election that is done in a death tax return form 706. That's where you can effectively double up on your $14 million exemption, so you can have a $28 million exemption. And you may say, oh, my spouse just died. I only have a $5 million estate. I don't need $28 million in exemption. I don't need that extra $14 million. We don't know what the future is going to bring. Somebody could pass a law one day that says all estates are taxed from $1 at 40%. I don't know, but it would be nice to inherit that $14 million exemption, right? So you're protected in the future. We don't know what the future is going to bring. So in California, working to prevent reassessment of real property under Prop 19. This is a highly specialized practice area of law. We get a lot of referrals from trust and estate lawyers who are nervous about counseling clients in this area of the law. Prop 19 laws can trigger a reassessment upon death, and that can significantly increase property taxes. We talked about that. Again, there's some things that you can do, and we cover this on other webinars. Much of this involves lifetime planning. There are some planning strategies that you can use when someone passes away, and we cover that one-on-one. So here is an example. If mom and dad have got a house that is assessed at $200,000, but it's worth $750, when that property gets reassessed, translation, the taxes are going from $2,600 a year to $8,300 a year, and you're not going to get the supplemental unsecured bill, which goes to the trustee, by the way, the personal representative. You might not get that for 11 months after you notify the assessor. So you may end up with this extra, $6,000 or $10,000 tax bill. And if you're the trustee, if you haven't kept enough reserve or figured that out ahead of time, you can't go back to the beneficiaries and get the money back unless you have a refunding agreement. So let me say this another way. The assessor's office The tax collector's office, they're very slow in getting this done. It takes a long time for them to send out the tax bill that you, the trustee, are personally obligated to pay. It's personal. Okay. So you need to make sure and figure this out. Probably want to meet with a lawyer. If you're a sophisticated person and really smart, maybe you can wing it on your own. But again, you're responsible for this. RMDs on IRAs. So if you inherit an IRA, a lot of people need counseling on this. I will say that not only are the rules confusing, and they've recently changed with Secure Act 1.0 and 2.0, and I'm speaking next week in Napa on this at a conference. Not only have the rules changed, but they can be counterintuitive. So really pay attention to that. The advisors, broadly speaking, kind of have an understanding about it. The institutions kind of have an understanding about it. And sometimes the institution's rules don't necessarily follow what the law is. So you really need to pay attention to that and need to check in with an expert. So again, specific rules apply to IRAs. If you have a taxable estate and you've got an IRA, the example here is Bob inherits $1 million IRA without thinking, he withdraws it all, $941,000 in taxes. You're going to pay federal estate tax of 40%. Plus state and local tax is 94.1%. So it leaves you 59,000. So very important. If you have a taxable estate, certainly with IRAs, I would really pay attention to the planning side. And again, probably beyond the scope of this webinar. So distributing assets and information to the proper beneficiaries as quickly and efficiently as possible. How long should this kind of answers the question, how long should a trust administration take? How long does it take to interpret the terms of the trust, provide beneficiaries with notices, get accountings done, coordinate with financial institutions, and resolving, disputes large and small? I would say, broadly speaking, a year is an acceptable period of time. Beyond a year, when you get into the 1 to 2 year time period, you're typically going to have a reason why the trust went on for more than a year. Beyond 2 years, it really starts getting suspect. It's kind of like having fish around for three or 4 days. It's like, wait a minute. If it's gone for more than 2 years, you're going to have a really good reason why this trust isn't wound up. And what I'm talking about are trusts that distribute all the assets. So I would say 1 to 2 years, you're safe. 2 to 3 is kind of a caution, but over 3 years, you're going to have to do some explaining to do. Now, if a trust creates subtrusts, I would say you need a lawyer for this. So if a trust says everything that trustee is going to handle all, wind up the affairs of the decedent, and then there is this trust that continues for the benefit of a daughter. And let's say this trust, John wanted to leave $500,000 to his daughter, Sarah, creates a subtrust. After his death, the trustee manages and wisely distributes Sarah's inheritance according to John's instructions. That $500,000 is kind of doled out to Sarah over her lifetime. You probably should have an attorney involved in that. And to figure out some ground rules and make sure that, because this is a very long engagement for the trustee, you're probably going to have to be doing accountings and probably have to deal with a lot of requests from Sarah where she wants more money, not uncommon. Legal documentation, so we can help prepare the necessary legal documents, the sort of notice to the beneficiaries you have to give, the certificate of trust, the abstract of trust. Any misstep can have very serious consequences and send the estate to probate court, right? So if a beneficiary complains, or in our example here, if Sarah says, I'm not getting the money I want, she can haul John into court. And that is not a challenge to the trust necessarily. She can say, he's been giving me $500 a month. I think I should get $1,000, right? And here's my reasons why. And that's not necessarily considered a trust. So again, those are a slightly different animals, really outside of the scope of what we're talking about here. We have offices. That brings us to the end of our time, our materials. We have offices throughout California, in Northern and Southern California. Next week, we have in-person workshops in our San Rafael office, February 4th, 2025. And we're going to do an estate planning workshop at 10 and 2 p.m. I will be presenting live in San Rafael. So the forecast is for rain. So if you want to come see me up in San Rafael, we'll be doing those out of our new building, and more details on our website to register. And next up next week is our LLC's corporation or partnership. Which legal structure is best? Which is suited for what's best for you? What's best for which asset? We're going to go through the highlights and the lowlights. And if you're watching this on YouTube, please subscribe to our YouTube channel and please post your questions on our in the comments section, and I answer those questions on our YouTube channel. If you have any questions, we're going to take questions now. If you're watching this on YouTube, please continue watching. Another video is going to magically roll up right after this one.